Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All righty, so we are about to get started. So this is the bond hearing of State of Georgia versus Kendrick Marshall, charged in warrant number 2024 WA02089, 02091, 02092, 02093, 02094, as well as 2024 CW 50605. Excuse me, that should have been 8, correct? Did I miss any charges? And these charges are for cruelty to children, stalking, possession of a weapon during the commission of a crime, criminal damage in the second degree, tampering with evidence, aggravated assault, and stalking. Representing the state is Attorney Freeman. Representing the defendants is Defense Attorney Creel. Your witness, Mr. Creel, Attorney Creel.
Thank you, Judge. As a preamble, Your Honor, I want to talk about what brings us to this day. Okay. Judge, OCGA 17-7-50 provides that the state has a duty to indict a person who is confined without bail within 90 days for a matter that does not involve the death penalty. None of the charges that the defendant is accused of involve the death penalty. And as such, we have applied for this young man to have a bond given him, and 1775 requires the court to set a bond if, in fact, he has gone more than 90 days in custody. Judge, he was arrested on February 13th of this year.
Okay, February 13th. Okay, all right.
Yes, ma'am. And as such, the 90th day was on May the 13th of this year. Today, of course, is May the 17th. And so we are now beyond the 90th day. It is further my understanding, Judge, that the representative from the district attorney's office does not know what day or if this matter will, in fact, be presented to a grand jury for their consideration. And so we are asking the court to set that bond. The matter first came before the court for preliminary hearing, Judge, on March 18th of this year. And at that time, I, with the consent of the defendant, continued this matter to the 90th day, given the violence that is alleged by the law enforcement officers in this case. And so that brought us to this past Monday. It is the state's practice that I have observed in the past to announce that they are ready. And then, of course, they tell us whether a witness was present. Seeing no witness present, Judge, we issued a waiver of the preliminary, a straight waiver of the preliminary hearing to get to today's calendar. We did that with the understanding that it is an observed practice that the state would be given at least a one-time continuance in the absence of a witness. And we didn't want to belabor the point in that we had reached and we're about to pass the 90th day. So that's what brings us before you today, Judge. Judge, there is a case that I want to talk about and share on the screen with you before we get into the charges.
Okay,
Judge,
so Attorney Lewis, first back up. Tell me a little bit about your client.
well, I plan to, Judge, but
Okay.
yeah, I'm absolutely planning to do that. I promise
Okay.
you.
All right.
Yeah. The case that I'm now sharing on the screen is Ayala v. State, which is cited as 262 Georgia 704. Judge, at position 705, our Georgia Supreme Court has said that the purpose of pretrial bonds is to prevent the punishment of a person before they are in fact convicted. And so we are
What statute is this? 17?
Yes, ma'am. Yes. So our coders in this state, of course, coded this partially in 1761 subpara E.
Okay.
But the language that I am reading to you is not coded in there. It's only found in the case. 1761E tells the court which factors it should consider when making that bond. But the reasoning for bonds being given is not in that code section. And the reasoning for the bond is cited in Ayala, which you should be seeing on your screen right now. And that is, of course, the prevention of punishment for a person for a crime that they've not been convicted of. And in this man's case, he's not even allowed to plead guilty or not guilty because it hasn't been indicted. That's a failing of the district attorney's office, not the court, and absolutely not him. And so that's why we're coming to you, Judge. And you correctly jump right onto it. 1761E are the factors that you're to consider when setting that bond. So he is entitled to a bond, and we're going to want you to look at those factors right now, given the circumstances that we have. Let me start, Judge, if I can, with the charges that this young man has, because the court talked about these charges, and this is important that you know this, Judge, because you weren't present, in my opinion, when we first got this case. In either case, we have a charge of discharging a firearm contained in one of the warrants. This charge in our state statute is under OCGA 1611-103. And 1611-103, Judge, requires or in essence prohibits the unlawful discharge of a firearm within 50 yards of a highway. That definition of highway is not important right now, Judge, for the purposes of this conversation. Just say it for this purpose, I'm going to say roadway. Judge, we have a warrant in this case that doesn't allege a distance of a highway whatsoever. And so this is one of the charges that he has against it, a warrant that does not allege that he discharged a firearm within 50 yards of any highway. It doesn't say it at all. We don't know what distance, or even if it was a highway. A second charge that this young man has, Judge, is tampering with evidence in violation of 16 OCGA 16-10-94. His purported tampering with evidence, Judge, is refusing to tell the police where he, the person who is accused, hid a gun. So in essence, by exercising his rights under the Constitution, He has been charged with tampering with evidence in 2 separate counts. And I didn't say which Constitution, because both the Georgia Constitution as well as the United States Constitution gives him the right as a person accused to actually remain silent and say nothing. But law enforcement didn't feel he had that right. And so they got 2 counts of tampering with evidence because of his alleged refusal to say nothing. A 4th charge, Judge, that this defendant is accused of is cruelty to children in the 2nd degree, in violation of OCGA 16-5-70, subparagraph C. And on the warrants for cruelty to children, it alleges that a person that is called a child has suffered some mental distress. It doesn't say that any physical distress occurred, but that the child suffered some mental distress, Judge. And it also fails to state the child's age or date of birth. I'm not going to go through the fact of telling you that I got a child that's 31 years old, Judge. And so here, it's missing the information that were we to have had that preliminary hearing, we would have been arguing that, of course, we did not. And we did not, like, as I said before, based upon what we were presented with on this past month. So now, Judge, let me turn directly to the question that you asked me about, which is my client. My client is 61 years of age, Judge. He is a convicted felon. He is not on probation. He has had violations of his probation while he was on probation, but he himself is not on probation, meaning that following those violations, he successfully completed his sentence. Amongst those things that he was convicted for, Judge, were burglary, entering auto, and some drug offenses. He also, Judge, in 2013, I'm told, was convicted of aggravated stalking in Cobb County, and sentenced to 5 years of confinement. That's 5 years to the door. But that does not involve the purported victim in this particular case. So in summary, Judge, he is not on probation anywhere. He is a lifelong resident of the state of Georgia. Up until last year, he resided in DeKalb County in his family home. And that was on the street in Decatur, Georgia. If upon release, he will reside with his sister, as that house was sold last year following his mother's passing. His sister resides in Fulton County, Georgia, on the southwest in Atlanta, Georgia. Her name, of course, is Miss Linda Kendricks. And if the court wishes to speak with her today, I have spoken with her. She is on her job, but she is prepared to get on the Zoom session and speak to you if you require it. Miss Kendricks, says that she is his last living relative, Judge. And I don't know the circumstances of everyone else's passing, but she told me to tell you that she is his last living relative. In this instance, he is accused of firing 2 rounds into a windshield of a car driven by or occupied by Miss Charlene Thomas. That is, and in one of those shots, it struck Miss Thomas in the leg. So that is the basis of the aggravated assault charge that he has. The basis set forth in the warrant for the stalking charge is that someone, we don't know who, but someone, according to the police, saw him in some bushes. And so I can't offer any more information on that, Judge. And the criminal damage in the second degree is, of course, the windshield glass breaking following bullet impact. I'm assuming, and we don't. It doesn't say in the warrants that in fact that is all of it, but I would surmise, Judge, that there could be $500 or more in damage to a windshield that's been broken.
Was the child in the car that was shot in? Is that what the cruelty to children?
That question, Judge, because I didn't see it in the warrants.
Okay.
So the nature of the cruelty charge says that the child suffers some mental or physical harm as a result of seeing or hearing. Cruelty in the third says only that. Cruelty in the second requires a little bit more. But in this case, Judge, I can't tell you that these children are even under the age of 18 because we don't have any information on that.
Okay.
And so my client, Judge, is a dialysis patient. He received dialysis 3 times weekly in Atlanta at a facility there. He is a person who has suffered heart failure as well as kidney failure. He is a recipient of supplemental security income. His sister, I know, resides in Fulton County and works in the school system. But he doesn't have a job at this point in time, and I don't believe SSI would allow him to earn what we would call even minimum wage as a part-time employee and still continue to receive those benefits. If I remember the code on SSI, it permits a person to earn $60 a month, and after the $60 a month, for every $2 of income, there's $1 in reduction of the SSI. So in essence, he can't be employed and continue to receive those benefits. And dialysis keeps him in a dialysis treatment facility, which would probably interfere with any employment he tried to have under the circumstances, together with his other illnesses. As far as the contact with the alleged victim, Judge, it is, and I never want to malign someone's character, but it is my understanding that his contact with that person is that she formerly worked at the dialysis treatment facility where he was a patient. It is my understanding that she has subsequently been discharged from that facility. And so he would not have a reason to have contact with her whatsoever. This event occurs in Clayton County. Judge, I don't know from this where the purported victim resides. But as far as I'm concerned, if released, Judge, he didn't have a reason to be in Clayton County. So, Judge, I'm asking for a reasonable bond to be set. I know that his benefits from the supplemental security income are insufficient to post a high bond. And I know that his disabilities would interfere with him, in essence, doing anything else. He is not the holder of a passport as a convicted felon. So there's no chance that he can leave the country legally anyway. And if, And if released and eventually accused or indicted, it is my belief that he would successfully be able to defend himself against these charges in the Superior Court of Clayton County. And so for all the reasons mentioned, no desire to have contact with this victim, no ability to tamper with evidence because any evidence is in the possession of the police. He's tied to a dialysis machine for the rest of his life, Judge. And so his ability to flee the jurisdiction, it is not evident in his history, and it is not evident in his condition. And then finally, there's nothing in his record that says that he won't show up to court. In fact, he has shown up to court and has gone to prison even after showing up to court. As said earlier, there are probation violations. I don't have any information as to the how he violated his probation, or the circumstances under which. The only thing I can tell you is that he successfully completed his sentence for the matters that he was on probation without further confinement for those. He was confined again for the ag stalking in 2013 in Cobb County, not involving the purported victim in this case. But he wasn't in prison for probation violations. And so I'd ask the court at this point in time to set a bond for a person who is 61 years of age receiving SSI that does not treat him as though he has been convicted of these offenses, and any other conditions you believe are reasonable to ensure that he appears in court and does not have contact with the purported victim. Thank you. And as said earlier, Judge, if you'd like to hear from people, we've got them.
Okay, okay, all righty. All right, go ahead, Attorney Freeman.
Thank you, Judge. First, I want to start by saying, and I'm going to go over Mr. Marshall's history, but Mr. Lewis indicated the act started was 2013, it was 2018. But I'm going to get into his history.
Okay.
But I also want to add, Your Honor had asked about the children, the ages, the information I have, age 12 and 15, who were present when Mr. Marshall was alleged that he shot into the vehicle, striking my victim. My victim.
Were the children in the car?
My understanding is that I don't know if they were in the car or standing right there, but what the victim has stated to my office is that her children were hurt emotionally, and she is seeking counseling for them. She has also indicated to us that she has safety concerns regarding the defendant, and she has asked that he remain in jail. She has also stated that he has attempted to shoot and kill her twice now. She stated that if he is granted a bond, she would like a stay away because the defendant has access to her home. And she said, and he indicated to her during this incident, I told you I was going to kill you. And so, Judge, I know that we are at the 90-day point, and Attorney Lewis has talked about Mr. Marshall's medical concerns and his age. But my victim has severe safety concerns. And I'm going to go through his history, but I do want to say that we believe, certainly, given what the victim has said, that he has access to her home, he knows where she lives, that there is a high risk of intimidation of witnesses, as well as a danger to society. Now, his history, Your Honor, and I'm not going to go from the beginning, but I do want to state that it begins from 1980. And that first charge in what's this, May of 1980 was a perjury. But again, that was 1980. So what I'll do is I'm trying to come closer to where we are, but he does have an extensive criminal history. And so let's see, 1997, let's see, that's the entering auto. Trying to get closer, 1999, there was a probation violation. Another probation violation in 1999. 2001, we have another entering auto. 2001, we have a theft by taking. And 2002, we have a burglary as well as an aggravated assault. In 2009, there's another burglary. In 2013, we have a simple assault. In 2013, we have a harassing phone calls. In 2020, we have a probation violation. I'm sorry, this an obstruction. 2013, I have a failure to appear. 2014, theft by shoplifting. 2014, a criminal trespass. 2014, another probation violation. 2017, simple battery and a disorderly conduct. In 2017, a battery, family violence, cruelty to children in the third degree. In 2017, another failure to appear. In 2018, act stalking. 2017, another probation violation. And then today's charges. So, Judge, what we have here is a defendant who, for years, has committed various crimes, has had numerous probation violations, which says that he certainly, that speaks volumes regarding how he views the laws of our state. He has this previous aggravated stalking charge. I don't know if it's the same victim, but it was out of Cobb County. And then we have today our charge, one of the charges is stalking, and then we have an aggravated assault. So I think given his history, he has shown that there is a great likelihood for him to reoffend, and that he is a danger to the community. Again, I know we are at or past the 90 days, but given all of his history, given the allegations of what happened in this particular case, the state does not believe that Mr. Marshall is a good candidate for bond. However, if the court is inclined to grant a bond, we are asking for a minimum of $100,000 total with a GPS as well as a curfew. And we would also want on the bond form to know exactly where he is going to reside. I know Attorney Lewis indicated a relative that he will be residing But I think that's just important, given that he's had several failure to appears in his history, to make sure that if he fails to appear again, that law enforcement will have some idea where to start looking for him. So again, we would like for him to remain on no bond status, but if the court is inclined to grant a bond, we're asking for a minimum of $100,000 with a stay away, a GPS, and a curfew.
You were last words, Attorney Moore?
Yes, ma'am, Judge. So, Your Honor, let me first apologize. I looked at the 2018 and saw 13. That's my vision on that one. Judge, what is important is the answer to your question about where were the children? And the answer is we don't know. We don't know if they were in the car, near the car, or somewhere else. It would be reasonable that children, regardless of what age, would be distressed if mom is shot. We absolutely, I think that's a normal conclusion. But that doesn't have anything to do with whether they observed it or not, Judge. And that's the question I believe that you're asking, whether the children observed it. And the answer is they could have been outside. They may have been in the car. The answer is, I think summarized is, we don't know, which is where I left the court before. Judge, you heard a lot about charges in that recitation of his history about failures to appear. But you didn't hear about the term of sentence and where the person was at the time. I would submit to you that on some of those events, you had a person who is confined and as such would not appear in somebody's court because he didn't have control over where he is appearing. I would also submit to you that his record indicates a lot of theft or theft-related events. We were not told whether these were first-degree burglaries, which would be residences, or second-degree burglaries, which would be in commercial establishments. And so we don't have that characterized here. But in any respect, we don't have any home invasion charges. We don't have anything that would tell us that occurred. I did hear of simple battery charges in here, Judge. I heard of one aggravated assault charge that went along with a burglary charge at some point in time. I think it was in the early 2000s, if I'm not mistaken. And I heard of a perjury charge, which began his contact with the law in 1980. So that being said, Judge, I'm going to turn directly to the state's request for $100,000. $100,000, Judge, is a dollar amount that I believe is sufficiently high enough to punish the defendant and to prevent his release from jail, which is exactly the opposite. The state says if you would issue a bond or a bail, the law commands you to issue a bail because the district attorney's office didn't do what they were required to do. But now to give him a bond of $100,000, understanding that he is an SSI recipient, would be to work against the purpose of that statute and work against the purpose of IALA. It would in essence serve to keep him in jail. Even though in all of the state's litany, they still did not tell you when they would have had him placed before a grand jury, when they would have his case indicted.
Okay, hold on, one question. Where did all this take place?
I think that,
Let's see. Judge, it took place at the defendant's residence because when the police when the police located Mr. Marshall, he had walked away from where it happened, and the victim was able to provide a description of him, and the police saw Mr. Marshall walking in the area.
No, okay, so when the car was shot up, where was the car?
Well, Judge, I don't know if it
house?
was in the driveway or on the street, but the incident happened at her home, at her residence. Mhm.
And is there some sort of relationship between the two of them?
Judge, I don't have the information. Attorney Lewis indicated in the beginning that his understanding was that the victim worked at the dialysis clinic. I don't have that information, so I can't confirm or deny that.
Does the victim advocate have that information?
I'm reading from the notes from my victim advocate, and I don't have that. That's not one of the things that that she would have asked her. In looking in the notes, it doesn't state if there had been a relationship between the two.
Okay, yeah, that's always important, what the relationship is. That's, for me, it's just important to know what the relationship is. If it's just he's angry with her because she didn't do something properly at his dialysis versus is it somebody he was trying to date? And so for me, the relationship is really important.
Well, Judge,
what access he will have in the future to her, that's important to me.
Okay, so if you can give me a moment, I can ask my victim advocate to contact the victim, because I believe she is watching the hearing. And I can have her contact her just to see what that is.
Yes, I would really need to know that.
I would submit to Your Honor that that's not relevant at this point. And the reason why I would submit that it's not relevant, Judge, is because it's going to place me in a position of now having to fight a case in front of you. Which is not.
All I want to know.
Which is not.
And it should have been in the warrant. It should have been in the warrant. We've been encouraging law enforcement. It needs to be in the warrant.
A lot of stuff.
It needs to tell me what parameters or special conditions I may need. The relationship is very important.
Judge, I would submit to you that you are absolutely right. It should have been in the warrant, along with a lot of other things that should have been in warrants, but they're not in the warrants. And even
I want to know, Attorney Lewis, I want to know the relationship.
And even understanding that, Your Honor, it's been 94 days that the state hasn't come back to amend the warrants or bring any new information before the court concerning this matter.
Okay.
And so if we're going to have that kind of information, additional information come in now, then we're going to present the whole story for the court. But I thought
I want to know, it's a simple question, and making my bond and considering my bond condition, I want to know the relationship.
Right.
I want to know, I need to know the probability of them having to see each other again or be in the same location. I mean, have they had a baby? I mean, I need to know the relationship.
You didn't ask that question whether they had a baby. The answer is no. They ain't got no baby.
It just goes to, okay, that's fine if they don't have a baby.
Yes, ma'am. No baby.
But I need to know the relationship.
None of that. Right.
Because there was testimony that this was the second time something like this had occurred. I need to know the relationship.
And I was going to object to you because that's improper. That was an improper argument at this point in time. There are no other police reports out there of a second time that the state has said exist, or cases that the state said existed. So that was simply put in by the state to color the situation. I've given you facts.
Judge, if I can respond to that, the only reason I stated that, I read the victim's statement that she had provided to my office regarding her feelings about bond. And so it wasn't meant to try to color this case or anything like that. And so it went to why my victim has safety concerns regarding Mr. Marshall.
So she provided that to the victim advocacy.
Yes, Your Honor. I read exactly from her statement.
Okay. I'll give it about 2 minutes. After that, I'll just go ahead and make my decision.
I do have information. And what she has indicated is that there was no relationship between the two of them. She stated that she took him to get groceries before, and that's the extent of their relationship.
How do they know each other? How do they know each other?
She formerly worked at the dialysis facility.
Oh,
Judge.
he worked at the dialysis.
No, she
He worked
at
where
the
he was going
he
to
was
get dialysis. Okay.
Yeah.
Okay. So, okay, she met him
Worked
at the
there.
dialysis place because she was employed there.
Yes.
Gotcha. Okay. All right. Anything else you want to tell me, Attorney Lewis?
No, Judge.
And so just to,
Oh, and I'm sorry, I didn't have any. Yes, there is. I had no objections to the other things that Madam Prosecutor requested. I believe she requested some level of monitoring for him. I also heard her to request a curfew. The only request within the curfew, Judge, is that that conditions be specified in there if the court is going to impose it, to permit him to do all of those things, medical, as well as, since he's been in jail confined so long, also visits with any governmental facility, as I envision that he's going to have to deal with the Social Security Administration again.
all right. So
I think that's all part of the curfew. I think that's standard in the curfew.
anything I do is
condition.
going to include the curfew and an address. Anything
Yeah.
I do is definitely going to include that.
We have an address for you. I did not read it out onto YouTube, Judge. I will provide it to you, however.
All right. And so this case, I'm ready to rule. So this case is quite disturbing to me, Attorney Lewis. We have the type of defendant that we try to protect our citizens from. He has a horrific criminal history, and most is violence, or at least things that are against, for instance, burglary. Simple. I mean, he has a problem with violence. He has a severe issue with hurting people. He is 61 years old and he's still doing it. He started in 1980s and he's 61 years old and he still hasn't learned. He's been in prison, he's been in jail, he's violated, he don't return to court. What do you want a court to do? I mean, this is
okay.
Yes, he is entitled to a bond for sure, by law. But he has spent probably more time with the judicial system than he has with his own family. Attorney Lewis, you've done a fantastic job with representing him. You have brought every possible positive thing that you could possibly say, but it is so his negative is so overwhelming, and I feel I just feel like him getting out potentially may lead to another citizen getting harmed or shot. This is his history. He has a history of violence and hurting people. And you would think, I was hoping when I saw his face, and I could tell he's older, that everything you were going to tell me was from the last thing was in 2009, and this is just something that just happened. But this is a history year after year after year after year. Other than God himself, other than God himself coming down here and saying, judge do this, there's no way that I would give him certainly nothing less than $100,000. He's on dialysis, but you're still shooting at people. I have a problem with people with guns. And then he not only did he shoot, but he shot her.
Judge, first and foremost, I'm going to object to that, Judge. You are now doing exactly what Ayala says you cannot do. You have assumed that he has shot someone. You have assumed that he has shot.
What I'm assuming is the state's testimony was that a person was shot. That's why he's charged with aggravated assault.
He's been arrested for that, but there is no jury nor judge that has said that this man shot anyone.
I am not. Well, let me rephrase, Attorney Lewis. The allegation that he actually shot somebody, not that he shot at somebody, but he actually shot somebody is disturbing. And his criminal history is disturbing. And if you don't think so, I don't know what else I can say. I know that's your client, and I know you have to zealously represent your client. And you've done that. You've done that, and you've done that very well. But at the end of the day, I have to look at those factors, and I got to determine, is he potentially, if he gets out, a danger to the community? Is he likely to reoffend? And I think the answer is yes, because he keeps doing it. He keeps doing it. So this is what I'm going to do. Because he is entitled to a bond because it's after the 90-day period, I am going to set bond. Because I don't like the fact that the children ages were not in the warrant, I've only set that. Though I'm going to set that bond at $2,000 because I don't like the fact that there was testimony that they are minors, but the fact that that was not in the warrant, I have concerns about that. So I've only set that at $2,000. And it was another one that the tampering with evidence, I've set those at $5,000 each. Now the rest. And please take this down so somebody can give me the proposed order. All right, so on the aggravated assault, I gave him $35,000. Again, the cruelty to children at 8-9, I gave him $2,000. Discharging a firearm, I gave him $20,000. Stalking, I gave him $20,000. Possession of a weapon, I gave him $15,000. Criminal damage of the windshield, $5,000, and the other tampering with evidence, $5,000. I'm not sure what that totals. If somebody can give me.
Yeah, just so I'm clear, you said on both of the tamperings, you said $5,000?
Yes.
I'm letting other people do the math, Judge. I stopped.
Okay, all right.
107. Do it again.
I'm coming up 107.
Okay, we have two at 107.
Okay. How would that be 107?
I don't.
Oh, because of that. Well, okay. 107. And then it's going to be the GPS, the curfew, and the address. I don't know. Hopefully, if Mr. March can get through this, he can get his life back on track. And I mean, just like myself, we have more days behind us than we do ahead of us. So every day he's living, he has the opportunity.
You all are talking about.
And Judge, question for you: Will your office be preparing the order, or do you need myself or Mr. Lewis to prepare?
I would like one of you guys to prepare that order. Also, to stay away from. Did she already leave that place? Or is she still employed there or not?
She doesn't work there, Judge.
Judge, I'm not sure if
Okay.
she still works there or not.
I was
Okay.
answering you. The answer is she doesn't work there.
She does not. Okay. All
No,
right.
Judge.
But still put a no contact in there. And do we know the name of the minor children?
Yes.
Okay, can we add the children in there too?
Okay.
And then of course that he's only on that curfew, he's only to leave to go to his doctor's appointments and.
Right.
I think
Well,
that
Judge,
language
there's
is
a
different.
standard thing on the curfew about, being able to, medical treatment, attorneys, things of that nature. So,
Also,
and
one more thing, he is not to have, and I don't understand why he wasn't charged with possession of a firearm by a convicted felon. I'm not sure why he wasn't charged with that. But I wanted to,
It's explained, Judge, in his refusal to be able to describe to the police where the guns are. That's one of the tamperings that you just gave him a bond on, that he did not tell the police where the gun was.
No, he's convicted aggravated assault, which is a felony, which means he should not have had possession of a firearm. So he could have been charged with that too.
And they don't have any guns.
So, Judge, do you want a condition that he cannot possess any firearms?
Yes, he cannot possess any firearms.
And Attorney Lewis, do you want to send me a message in the chat or via text or email the address?
Yeah. I was gonna do that. Which way do you want it, Judge, to you and her on the chat, or is it okay to just send it to Madam Prosecutor in the email?
You can send it to Attorney Freeman, let her approve it, make sure everything, and then once it's done, she'll forward it to me and copy you. Oh, there it is in there. You see it? It's in there, chat.
I see it. I'm just asking so I can have it in the order.
Okay.
That's my staff being efficient, Judge.
Okay. All right.
Is that in Atlanta?
Yes.
Yeah.
Okay. Oh, I see it now. It came up. Okay.
All righty. You guys have a great weekend.
All right. Thank you, Judge.